Oh, snap. Welcome back to the channel, y'all. My name's Patrick. Take a second. TikTok, hit the follow button if you're new. Tap the screen like crazy for me, please, and thank you. YouTube, hit the subscribe button. YouTube, y'all know what to do. Come on, hit a little subscribe action. Hit the thumbs up button if you're new. Let me know in the chat. TikTok, everything should sound good because nothing changed for you. YouTube, I'm trying out some new sound stuff, so y'all put some thumbs up in the chat. I should sound good right now. Y'all let me know as you're coming in if you can hear me okay. And then the sound on the video should be pretty good as well. Ooh, April, thanks for the iced coffee action. I appreciate that. Y'all hit me with those little bear things too. That's what we're trying to get right now. We need a little bit of that bear action. 100 of those bad boys. It sounds good? Okay, sweet. So let me know if I need to adjust the volume on this thing, but everything should be good. Y'all hit the like button. Do all the things. Bryan Kohberger. Oh, hell. Idaho judge slams Bryan Kohberger's defense over the DNA, y'all. Because remember, this is about the evidence that they got from like the genealogy thing. It's like the 23andMe type thing. So to get the dad's profile, whatever it was. Y'all ready for this? Hit the like button, do all the things, and let's go.
Your Honor, our position is that the court should suppress the IgG identification and everything that flows from that. This is supported by...
Oh, hell. Y'all sound check. Everybody good? Everybody good? You can hear that? Thumbs up in the chat.
By Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IgG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required. None was given. And so this must be suppressed.
Wow. Cassie, thank you.
Your Honor, I'd like to identify the 3 stages.
They didn't have a warrant for that stuff? How did they get it? They just asked for it and the people were like, oh, here you go. Does it sounds better than usual, doesn't it, YouTube? It sounds better than usual. Thumbs up.
And they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample, Othram Laboratories, to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody.
What? You what?
The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pool in Pennsylvania, and there was no warrant for that trash pool either. All 3 of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor,
that's crazy. How would they pull all that stuff? How would they get all that stuff and then just be like, oh yeah, by the way, we did have a warrant. Damn.
For the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see
Oh,
from
hell.
the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions
That is crazy. Something this big, a case this big.
to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the JED.com file. I don't have...
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well,
Ooh. Ooh. The judge said, hold on. They didn't search his. It was like his dad's and all his, like, that side of the family.
Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger's DNA was on the knife sheath.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA.
Right.
Those databases don't churn out a name and say this is
I have a
suspect.
privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor,
It kind of seems like that's what she's saying. Uh-oh, SpaghettiOs. By the way, TikTok, hit the follow button if you're new here. My name's Patrick. If you like true crime, we're live every night. YouTube, do the same thing. Hit the subscribe button. Hit the thumbs up button for me too, y'all. Let's spread this one out. This is getting crazy, y'all. This is Bryan Kohberger. This is the judge slamming his defense about this DNA.
Is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
But not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
That's a loaded question.
Why is it a loaded question? Isn't it a factual
What?
question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position.
I agree. That part was is an assumption. In my hypothetical, I said my DNA that was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Well, Your Honor, our position is that
Whoa.
this work was not
Thanks for the
done
follow, Joe.
lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in
outstanding when
violation
he's
of his
accused.
rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody.
You're
for
saying
2
that,
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that.
Yeah, that would be crazy.
And it seems to me to be an extreme position to
Thank
take
you,
in light of the case law, and I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different
So
search.
I'm going now to, I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some
Right?
cases.
I did, I think, one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about.
Okay.
Our first point is it was an illegal search. And this is if
The search,
for the
which
court's
search?
assumption,
Which search? It was illegal.
first the snip at Othram, then the snip at the FBI, and then the trash pool.
You're talking about the DNA testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. there are no results there. I'm talking about the next set of moves that are super secret that happen when there's a portion of the DNA taken and it's searched by Othram to create a
Man, I'm getting the feeling this judge is not buying any of this. Like, he's just sitting there like, excuse me? What now? What are you saying?
snip. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the snip ourselves. That's what I'm talking about. Those are the problems. As far as asserting family,
Specific DNA tests of the sample that goes from legitimate to illegitimate?
yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath.
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose, and I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
site to that.
I'm sorry?
Can you give me the site to the Davis case?
Can. Give me 2 seconds. 2 seconds and glasses.
2 seconds and glasses.
And I apologize because my memory tends to be fact-based and not name-based, and so that's my liability.
Well, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. I can't remember what page.
Oh, hail.
It is 690 F 3rd 226.
Okay. Go ahead.
All right. And so those are the 3 areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big.
Expectation of privacy while you're committing a crime? What? Hey, we think you might have done this, and we're gonna use all the tools at our at our disposal to find out if this DNA we found matches your DNA. You can't do that. I have an expectation of privacy. What? Does it just not make sense right now? Like, this seems very weird. But let's continue. Y'all hit the like button. TikTok, hit the follow button if you're new here. My name's Patrick. If you like true crime, we're live every night. We listen to all kinds of things. But come on in, y'all. Hit that follow button. Let's keep going.
Is that from Othram? And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. it says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Don't suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IgG databases that changed their rules in terms of use after a different case used IgG to solve it, because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
Got to be a standing.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required.
Man, this sounds like the defense is like, hey, you found something that he didn't expect to have left behind. Can you not use that? We didn't want you to find that. You know what I mean? Like, we didn't want that to be there. So can y'all just not use it? Just don't use it, you know? Hey, you know what? It was a warrantless search. And because that violates his constitutional rights, he should get away with this. What? Oh my God, I gotta hit YouTube with the zoom on that one. Just like a... All right, let's keep going.
For this type of
Let's hit those bears, TikTok. Come on, y'all.
inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law, that Carpenter, thinking about cell phones. That's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle with, well, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene.
Yeah. That part. That's literally what I'm saying. Oh, I left DNA at this crime scene. Can you just not use that? I didn't mean to do that, so my privacy is being infringed on because y'all found my DNA here. What?
That DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
And not go to a crime scene.
Yeah, what the hell? That's a horrible argument.
What? I don't think any of us can leave our house without leaving DNA everywhere. Yeah, but not at a crime scene, unless you were there.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here, and that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you went.
Everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor,
Does TikTok connect to the router at my house?
How dare you!
Is a series of tubes how I'm connected to the interwebs at the present moment in time?
that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you drive your car to go to the doctor. Your cell phone's heading on those towers. DNA is even more personal than that. The tests are
No. What? What the fuck? Oh my God, y'all. Did you know that DNA is more personal than your cell phone pinging on towers? Holy hell. You mean to tell me that my iPhone isn't the only iPhone accessing the routers so that the TikTok can get on my screen?
so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches, and that's what we're asserting here.
Reese's searching for the stars, or reaching for the stars. Yeah, it feels like that he wasn't the only one looking at the stars. This is crazy. I wonder how much DNA, what surfaces I've left DNA on. Oh man, I shouldn't have said that. That sounds bad.
There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left if that's going to be the standard. You put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look.
I don't understand where you're coming from with any of that. I'm a criminal that left DNA on at my crime scene, and now I would like an expectation of privacy, please. How dare you?
How dare you!
Use my DNA to link me to a crime I committed. Preposterous, I say. Oh, I hit the wrong button. Son of a biscuit-eating frog. I gotta find the spot again.
Clear to that extreme, and the court shouldn't. The court should look
Well, I
at
actually
the
got it almost there.
Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different.
What? Then, okay, so is this lady saying that all the criminals have to do is just be like, I don't consent to my DNA being searched? What is going on? Like, every criminal will be like, I don't want my name, my fingerprints, my DNA. I don't want cameras in the places that I was at searched. I don't want, the people that are going to testify against me, I don't want their brains and their memories searched. They're going to recall the events of what happened? No, 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 no. That's an invasion of my privacy. That's an invasion of my privacy because they're using the inner workings of their brains. What?
You what?
If I might be completely misunderstanding what she's saying, but I hear, like, what I think it sounds like is that she's saying that. And if so, talking about brains, you got a smooth brain. Might be missing some grooves because that shit is like a bowling. That is a smooth ass brain. Let's keep going.
The
It's
FBI
almost over
went
too. Dang it.
into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we
Secretive? Lady, what do you want the police and the detectives to do? Live stream all their investigations? What the fuck? Hey, this is Detective Patrick. I'm on my way to arrest Bryan Kohberger. I done got his DNA. I'm on my way. I hope nobody tells Bryan Kohberger that I'm on my way, but here I come. Wow. Let's continue, shall we?
are learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's
Oh,
why
my
there's
goodness.
so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not.
Man, lady, I don't know. You're making Santa Claus back there look really good right now. Right there. He's like, ho, ho, ho. It says here Mr. Kohberger's on the naughty list. Give him life in prison. This is crazy.
The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Right? Yeah. He's going to stand up and be like, I was told there'd be milk and cookies here. I've got a pitcher of water and this bitch saying shit that doesn't make sense. Oh, I can't. Don't tell Santa's secrets. Oh my goodness. This is crazy though. I don't know. Y'all tell me what you think in the comments. Maybe I'll pop back on and do another one because this is nuts. Is there any other? Hold on. You know what I'm going to do? Hang on. Hang on. Y'all don't go anywhere. Let me look up and see if there was any other Bryan Kohberger stuff that came out. 2 hours? Oh, East Idaho News did one.
We like East Idaho News. He's good. Let's see what he's got to say. Woo-bam! Hang on, y'all. East Idaho News. Well, let's watch his. Let's watch his live stream. He did Courtroom Insider. Kohberger wants evidence suppressed and wants search warrant challenged. I thought they didn't have a warrant. Now he wants a search warrant challenged. Thumbs up in the chat. Should we do it? I tell you what, TikTok, hit me with the bears. Let's crush the bear goal. And YouTube, let's get 100. Let's get 100 likes, y'all. And we're going to put this one up. Hang on a second. Let me share it. I got to put him up in the description. You go up and you get removed from the studio. Well, bam, there he is. All right, y'all, let's get 100 likes and let's check this one out. This was the guy that we followed during the Lori Vallow case too. He was there like every friggin' day with Lori Vallow. Oh my god!
How dare you?
Aaliyah, thank you. Taryn, thank you. Yes, y'all, we're gonna hit it. Thank you. Let's keep going. All right, let's start this one. Y'all, make sure you subscribe to him. I'm gonna pin him down in the description. I'm going to pin him down in the description. East Idaho. I'm not so. Oh, because I'm on the Mystery Project. Yep. Sorry. Make sure you do what I just did and subscribe to East Idaho News. I was subscribing on the Haunted side because that was the last time we watched it, the Lori Vallow case. Damn. All right, let's go. Amanda, are you a local to Idaho? No, but I am in northern Nevada, so that's basically Idaho. All right, let's go. Oh, hit me with it.
Good evening, everybody. It is good to be with you. I'm Nate Eaton. Welcome to Courtroom Insider. It is Thursday, the 23rd of January, 2025. And there is some progress, I guess, maybe. I don't know if you could call it progress. We could say there were some arguments today in the Bryan Kohberger case. But most of the day, we were greeted with this. The hearing started at 9 a.m. and for hours, I believe 5 hours, 5.5 hours, everything was in a sealed portion of the courtroom. And the judge Hippler had said that the proceedings would likely go between closed and open throughout the day. And mainly it was closed until around 3 o'clock, I think, 3-ish. And then it stayed open the remainder of the day until court adjourned for 5 o'clock. The big...
Y'all, is the sound okay? On YouTube. On YouTube, is like the video and the my microphone, is it pretty balanced?
Topic of the day of the whole purpose of this hearing is that Bryan Kohberger's attorneys are really arguing for two things. One, they're arguing that some evidence should be suppressed, specifically evidence related to the investigative genealogy or investigative genetic genealogy. And in a minute, our guest here tonight will talk a little bit more about this. But what that means is, you recall that Bryan Kohberger's, they were able to track his dad's genetic genealogy through the print that was left on the sheath at the home near the University of Idaho. It matched genetic DNA.
Man, he's probably mad as hell he left that.
To his father, Bryan Kohberger's father. The defense is saying that evidence was illegally obtained, was not properly obtained, and they are arguing that it should be thrown out. Now, that is a big deal if that happens. That will change the course of the entire case, because obviously that's kind of a slam dunk in so many ways, you could say. If the genealogy, if the DNA found on a knife sheath at the crime scene matches the suspect's father. Now, his father obviously wasn't there, but genetic DNA, they're able to track.
Yeah, that would be crazy as hell.
Who it matches to. In fact, the Christopher Tapp case, if you followed that at all in Idaho Falls, It wasn't him who committed the murder. It was another guy named Brian Dripps, the murder of Angie Dodge. They were able to use genetic genealogy, DNA, to find the real killer. So it solved that case, and it solved many more cases, technological advancements that are just new within the past few years. So the main argument.
But his defense team is saying, don't use that. How dare you, use modern technology? How dare you get better at finding these people? Don't do that. Stop doing that. It's an invasion of privacy. Really?
From his attorney.
You know what's an invasion of privacy? Breaking into someone's house and then taking their life. It's a pretty big invasion of privacy, I'd say.
Today, at least publicly, that we saw from what
me crazy!
We understand, this was discussed most of the day, or a lot of the day. Then it became public. The hearing became public, and Ann Taylor, Bryan Kohberger's attorney, jumped right into why the evidence should be suppressed. Here's just a little bit of her argument.
This is what we just watched. For several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required. None was given. And so this must be suppressed. Your Honor, I'd like to identify the 3 stages. And they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All 3 of those stages.
Didn't they not pull his? They pulled the neighbors? They have to get a warrant on the neighbor's trash?
Stages of this case, there should have been a warrant, and there wasn't, and this must be suppressed. This is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That
Okay, yeah, we
search
heard
was
that.
done by making a profile in Othram Lab. That search did not, there they is more than twice as big when it gets to the FBI from there's a subsequent test.
Why? So that,
and there's something that's lawfully held, but there's a subsequent test.
God.
Okay, so that was Ann Taylor talking back and forth with Judge Hippler. The state, of course, was able to get up and argue why it should be.
Yeah, this part. This is what we wanted to hear, y'all. This is what we wanted to hear, what the state replied to that.
Why it should not be suppressed, why it should be admitted. Here is some of the state's argument.
The
Ho!
defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide, at a crime scene. There is no case law.
Yeah, that part.
Anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding
that part,
whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And
By the way, TikTok, hit the follow button. And if you want to watch this with us, we're live over on YouTube as well. And who knows what's happening with TikTok, so y'all come on over, subscribe to the YouTube channel. It's in the bio too. Click my face, go to the profile. Click the links down there at the bottom. You'll find it. Or just search The Mystery Project. Mods, will you pin that? The Mystery Project. We're live there right now too if you want to come over and watch the video with us.
And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as
come on,
crime scene as it gets. And that's where the DNA was found, and they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard.
The defense attorney is like, damn it, I got to scratch off HIPAA violation now.
Of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research." So the defense is positing this question of what could law enforcement do with the DNA, and then decide whether or not there's a violation of the Fourth Amendment. But that's not what the U.S. Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA. DNA can reveal a bunch of private medical information. And the U.S. Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not, in fact, tested for that end."
So that is their point of view.
Yes.
Now, if you want to watch all of today's hearing, we have it on our YouTube channel. It does get technical, but it's interesting to hear this judge question both sides with their arguments. He did not
Terry Ann, thank you so much.
Rule on suppressing the investigative genetic genealogy, and he said he'll take it under advisement I would imagine there'll be a written ruling here in the next few weeks. And it will, in my opinion, it will change the course of the case if he does suppress this evidence.
Right.
The other big thing, by the way, if you're just tuning in, thanks for being here. This is Courtroom Insider. I'm Nate Eaton. Every Thursday night, 7 o'clock, we talk about different cases. This all started with the Lori Vallow case back in 2023, and then we
Yup, we've been here since then. That's what I was saying, y'all.
did Chad Daybell's, and we're gearing up for another Lori Vallow trial here in a few weeks. But tonight,
Yeah, the one in Arizona.
we're talking about Kohberger. Would love to know where you're watching from and if you have any questions. And in a minute, we're going to bring on Howard Blum. He's an author. He wrote a book all about this case called When the Night Comes Falling, a Requiem for the Idaho Student Murders. You will hear
What?
from him. It's an
There's already
interesting book.
books?
We'll hear his take
There's already books? Oh, thank you, Terry Ann. I saw that last second. Thank you.
on what has happened and where he thinks the trial will go. So I'll only be talking here just a few more minutes. Of course, Bryan Kohberger on trial for the murders of 20-year-old Ethan Chapin, 21-year-old Kaylee Goncalves, 20-year-old Zaina Kernodle, and 21-year-old Madison Mogan. All of them were stabbed to death in a home back in November of 2022, if you can believe that it's been that long. So the other issue that was talked about today is
That is crazy.
the defense is requesting what's called a Franks hearing. And what a Franks hearing is it's a special hearing where a party challenges the veracity and validity of a search warrant. And the defense is saying that the search warrant that was obtained in this case, one of the search warrants was not properly obtained by the police. And the defense argued 13, I believe it was 13 reasons why they believed it was not properly obtained. The state said it was properly obtained. The judge did not rule on that. If you want to get into the specifics, I won't break it all down tonight, but if you want to get into the specifics of the arguments, again, you can go watch that on the East Idaho News YouTube channel. Court will be back in session again tomorrow at 9 a.m., where more will be discussed and we will stream it more. This was the judge set aside 2 days to go through all of these motions, to hear all of the motions that need to be discussed so that things can move forward. As of now, the trial is set to begin in August, this summer. So you have January, February, March, April, May, June, July. You've got about 7 months to prepare for the trial.
Dang, that is crazy.
And get a jury ready and get everything ready to go. And the trial is expected to be quite long. Interesting bit of trivia: the Chad Daybell murder trial was the longest trial, from what we've been told, in Idaho state history, and this trial will likely beat that. It should be long, and it's also going to be in that same courthouse, different courtroom, but the same courthouse, different judge, of course, and hopefully it will be televised, and so you can watch it. Okay, so
how was the Chad Daybell trial the longest in Idaho history and not just like 5 minutes? Do you know what I mean? Like how was that not just like, well, okay, here's what we have and here's what happened. Oh, yep, guilty.
That's what happened today in court. Not a lot of major details to report, but there was some interesting news to talk about, and we'll have more tomorrow. We should. Now I want to get to my interview with Howard Blum. Spoke with him today. He is the author, as I mentioned, of When the Night Comes Falling, a Requiem for the Idaho Student Murders. This is a book that came out, I think, about a year ago. He spent some time there near the University of Idaho interviewing people and putting his book together. And let's go ahead and roll that interview right now. So Howard, why don't we just kick off? Out of the past 2 or 3 years that you've been following this case, what has been the most interesting aspect to you?
Well, this case has been a puzzle from the get-go. I mean, the fact that someone would go into a house filled with students and decide to kill them, to murder them savagely. This whole case is a mystery in search of a motive. We've never found a motive. We've never found a murder weapon. And yet we're heading to a trial and we hope to get answers. I don't think we'll ever get answers to these really perplexing problems. We certainly will get a verdict whether someone is guilty or innocent of the crime, but we'll never get our the questions that we really need to know answered.
What do you think his defense might be?
I think at this stage, his defense is really not to deal with the facts of the matter. What his
No, remember the fact was they said he was stargazing.
attorneys are trying desperately right now is to get rid of the death penalty. They're trying to raise all sorts of reasons so that the death penalty will not be applicable to this case. They're going back to that enough discovery information has not been presented, as in the Lori Vallow case, and that therefore maybe that's a reason for not to have the death penalty. First, they tried that it was cruel and unusual. Nothing is going to work. This is going to be a death penalty case. Then their next attempt, and this is what they're doing just as we're speaking right now, they're in the courtroom.
That is crazy as hell. Oh, hey, this person got found guilty of taking the lives of 4 people. So, but it would be cruel and unusual punishment to take their life.
What the fuck?
That is crazy to say out loud.
Trying to get rid of the evidence. They're trying to impugn the evidence that led to various warrants, or even sometimes led to actions without warrants. What they're saying is that the genetic information that the FBI used was illegally obtained. What this means even more specifically, the government is allowed to access certain databases, but some databases such as Ancestry.com and 23andMe, they say the information on those databases are prohibited from federal or police investigators. They are trying to find out, this is the Kohberger defense team, whether or not the FBI, in their zeal to find an answer to who was the killer, access those cases. The judge has so far not allowed them all that information. It doesn't appear that way. If they can impugn that evidence, then they have the fruit of the poisonous tree. If everything that led them to go looking for cell phone records, that led them to have the search warrant into the house, all this ultimately
That still drives me nuts.
builds to the moment after Kohberger
Oh, oops, you found some DNA. Can you just not use that?
is arrested in January.
No.
And they take a cheek swab of him at the jail in Pennsylvania. It's that cheek swab which definitively links him to the DNA on the knife sheath that was found in the murder house. That would seem to make it an open and shut case. But if they can get everything excluded from the case that leads to that cheek swab, that's what they're trying to do. I think it's a long, hard mountain to climb. I don't think they'll succeed, but that's really their only hope at this point.
And if they could, though, that would change so much with this case.
That would change the case completely. Right now, they have a man whose alibi is that at the time of the killings, he was off in a mountain park on a foggy night by himself, looking at the stars at 4 a.m. And they have confirming cell phone information saying he was in other places. The alibi is, to my mind, patently absurd, but they're going to try to twist the facts, manipulate the facts, get facts excluded to try to make their case. I think they realize they're not going to be able to do that. What they're really hoping to do is prevent Kohberger from being put to death. And at this point, the Idaho state legislature is even moving more forcefully to make this a murder case where the person will be executed by rifle fire. There's a bill right now in the Idaho state legislature was just introduced saying that they have to have the only solution in a death penalty case, the only enforcement will be by a rifle squad.
Right, yeah, because of the issues that
Yeah, it's the damn chemicals, y'all. Remember, we did a video about this like 2 years ago, it seems like now. It was crazy as hell. The people get the warrant to the warrant to somebody, but they can't get the stuff to do it. in time. It's crazy.
Idaho had executing Thomas Creech last year. They tried to put him to death. They couldn't get a vein. And right now there's currently not a facility where you can do a firing squad for a death penalty case. And as you mentioned, the lawmaker has proposed this bill. Let's go back, Howard, to when you first decided to write a book about it. What was it about this particular case that piqued your interest?
I first got involved in this case just really days after it happened. We were sitting around the Thanksgiving table in 2022, which is just about a week after the murders occurred. And I was in Connecticut, and people started talking about the case. And as a father with 3 children who've gone off to school, and this was, very, very affecting, but also as a reporter, the mystery. Why would someone do this? How could this have happened? Was there a larger story? And I headed out to Idaho with the conceit that maybe I would get to the bottom of things. And when trying to put the pieces together, I certainly didn't solve the case, but I was able to get many elements of the story that made a richer story. I say richer story, here you have the Kohberger family. You have a father going on a cross-country trip with his son, and in the course of this cross-country journey, he's sitting in a car, shoulder to shoulder with him, and he's coming to the realization, oh my gosh, my son might just be a monster, but he can't quite get there. He can't really say this about his own son. And then you have the victim's family, how they're trying to live in the aftermath of this horror, the compromises that they're trying to make in their own life as they move forward. And then you have the defense trying to build a case which a man, I believe, they think is guilty, that they know is guilty, and yet they're trying to put together the defense. All those elements, to me, combine to make what is a very compelling story, and one I wanted to tell in When the Night Comes Falling.
When Bryan Kohberger, you mentioned the drive across the country with his father. We've since seen the video of him getting stopped not once, but twice within like an hour or so, very short.
9 minutes. There are 9 minutes in between the stops. It's hard to believe. Here he is driving across
9 minutes in between the stops.
The country. At this point, when the stops occurred, I was able to find out by talking to people close to the face. Bryan is telling his father about that he has problems at the Washington State University. He's having problems in the department, but he's convinced that he'll be able to overcome them. He'll get a hearing, and they won't be forced out, and he won't lose his fellowship. While this is happening, the father is also noticing his son's mood. When he first came out to the Moscow Pullman Airport and his son picked him up, from that moment on, he knew something was off. He's known Bryan's mood, and now all the pieces are coming together.
Man.
I mean, the father knew. The authorities at this point were looking for a white Hyundai Elantra. He's sitting in a white Hyundai Elantra. He's sitting with his son, who lived just 9 miles or so away from the murder scene, and he knows his son has a volatile temperament. And he's beginning to wonder what this is happening. And then he sees in the rearview mirror flashing lights. The police are coming, and he figures, this is it. Something is about to happen. Then they let them go. It's just a traffic violation. He was tailgating. And then 9 minutes later, it happens again. And the father just doesn't know what to believe, and he just wants to get back to Pennsylvania, where he thinks he'll be safe. And so does his son think he'll be safe. But
Wow.
of course, by then the FBI is on their tail, and they're closing in.
And so you think that his dad at that point may have suspected that his son could have been responsible?
I think his father suspected, from what I've heard, even before he went out to see his son for the holidays.
Hey, y'all calm down.
To drive back across country with him. You have to realize Bryan Kohberger at this point is 28 years old. When he first goes out to school in August, his father, who's 68 years old at the time.
Can y'all hear the cats going haywire right now? Hey!
67, really, makes the trip with him. The family doesn't really have any money, but the father is taking time off to make this trip. He knows his son has problems. He knows his son has a difficult time fitting in. The first thing his father does when he gets out in August to Washington State University. He goes up to someone in the apartment building and he says, "Can you watch after my son?" They're very concerned, the Kohberger family. They know that this was a young man with difficult problems, and they were treating him almost like a child.
So he ends up getting arrested in Pennsylvania. You know, you read about the circumstances surrounding that arrest. It sounds like it could be in a movie.
Oh my God. Hey.
You know, walk us through, for those people that aren't familiar, as far as taking out the trash and the police coming in the middle of the night, how that all went down.
When the decision is made that Kohberger is a suspect, this is after Kohberger has driven back to Pennsylvania and he's living in his parents' house in Albrightsville, Pennsylvania, in sort of a gated compound of once were summer houses, now they're all year-round residences. And the FBI still needs to get more information so they can do the DNA. They need to get a hold of Kohberger's DNA. So the decision comes up, they're going to have what becomes known in police law as the Great Trash Robbery. They go into Kohberger's family's
A great trash robbery.
house, the garbage cans outside the house, at approximately midnight. And one state Pennsylvania State police guy goes into the trash can, grabs the trash and takes it out, and they have this trash analyzed. They get it sent back to Idaho. What they're trying to do is find DNA in the trash that will match DNA that was left on a knife left behind on the scene, on the button snap of a knife sheath. They go through the process, and it's not a quite match. It doesn't match. And I thought, all this is for nothing. Then they do another test, and they see the DNA on the knife sheath is a match to the father of the person who left the knife sheath. And they realize they're in the right place. What Kohberger had been doing is he had been separating his garbage. He had not been putting it out in the family's trash. He'd been putting it into plastic bags. His sister saw him doing this, sorting the garbage into plastic bags. And he was hoping that this would allow him not to get caught. Then the FBI decides to do their raid. They go in with about 40 of the Pennsylvania State Police special.
Separating out the trash, your trash from your parents' trash, for just no reason at all, Brian. Just felt like my trash isn't good. Your trash isn't good enough for my trash.
Emergency response team. This is a sort of a SWAT team. They're all wearing body armor. They're heavily armed. They go literally crashing through the doors, and they walk in and they find Kohberger
with gloves on.
Kitchen.
Exactly.
He's sitting in the kitchen in his house, in his underwear, sorting his garbage into plastic bags. They catch him doing this, and they arrest him and take him away. The defense is now saying that arrest, that sort of use of force, that use of surprise in the middle of the night was unnecessary, that they could have picked him up anytime up on the streets of Pennsylvania.
So the defense is, how dare you arrest him at night? You should have waited to the daytime.
Yeah, on the countryside. However, the prosecution will say that this is a man suspected of killing 4 people. We wanted to give our law enforcement agents as much protection as possible. And I think their argument will hold up in court.
You mentioned Bryan Kohberger and us never knowing the why, about why he did this, probably never knowing. But any idea, as far as why that house that night? There's been talk that he was obsessed with one of the girls, one of the victims. And why, was there something particular about that date, about doing it that night? Or do you think it was more of a snap judgment, do it right away type thing?
Here's what I think what happened. And it's speculation, but it's informed speculation. You have to, and to reach my theory, my hypothesis of what happened, I go back to the night in question, the night of the killings, November 13th, 2022. What happens is first, Kohberger drives by the house, not once, not twice, but 3 times. I don't believe
Oh
he was
man.
casing the property. What I do believe his mind was made up to commit murder. I think he was trying to find the will to become this monster, to cross this Rubicon and to become this monster he envisioned in his mind. Every time he goes by the house, he's not quite there yet, and he drives away, but then he's pulled back like a magnet, and he returns to the scene of the crime. And when he finally parks his car above the house, and there's an incline to walk down, when he turns off the engine, that's his real commitment that he's going to engage in a murderous act that night.
But for what reason? What is the purpose?
He enters the house through the kitchen door on the second floor. There's a sliding door, it's left unopened. If he was wanting just on a sheer rampage to kill, there are 2 bedrooms filled with students on that level. He ignores them. He walks up a narrow flight of stairs. He seems to know where he's going. There are 2 bedrooms on this 3rd floor. He goes immediately to the one on the right, and I believe that was the bedroom of Maddie Mogan. I believe Maddie was his target. Kaylee Goncalves is sleeping there that night. She's staying in Maddie's room. She really isn't even in school that semester. She's living up in Coeur d'Alene, and she just comes in that night. He goes to kill one girl. Why does he choose Maddie? There's no real logical reason. What I believe probably happened, she was a waitress at the vegan restaurant, the semi-vegan restaurant we went to, the Mad Greek in downtown Moscow. And
Didn't the owner of that come out and say, no, that never happened. He was never there.
he might have seen her there. Were words ever exchanged? Did she ever wait on him? There's no record, no documentation of that. But for a man like Kohberger, I think obsessions come to him easily. He had been a heroin addict. He had lost 25 pounds of weight. He did things in obsessive ways. And I wouldn't take much for him to become fixated on Maddie. I then believe he followed her. He saw the parties that were going on in the house. He saw these young people who were living there. And he was an outsider. He was excluded from this kind of life. And their
This is Howard Blum. He's just he's speculating right now.
presence, he felt,
But he's talking about his book.
was a rebuke to him and the life he was living. And the only way he could continue to live, his vanity required that this woman who had excluded him, Maddie, be eliminated. Once he got into the house, everyone else was collateral damage. Haley in a room tries to fight back. She can't escape. He kills her too. He goes downstairs. He's then confronted by Ethan Chapin. Ethan is 6'4", but that's no challenge to the assailant that night. He takes a knife and slashes Ethan right at the jugular. Ethan collapses.
Ethan was 6'4". I didn't know that.
He then goes into the bedroom, and there is Ethan's girlfriend, Xana, and he tells her, and this was heard by one of the surviving witnesses, "Don't worry, I'm not going to hurt you. I'm not going to harm you." But that, of course, is a lie, and she's killed too. Then as he's walking out of the house, trying to make his exit, a really strange, perplexing moment happens. One of the girls on the second floor gets out of the bedroom and she sees him, Dylan Mortensen. And she sees him and she's in a frozen state of shock. That's how she describes it. She says nothing. And at this moment, Kohberger, or whoever the killer is locked in his own state of rage, his own armory of hate, and he doesn't even notice her. If she had spoken up, if she had said one word, then I believe she too would have become a victim. But instead, she retreats to her bedroom. Kohberger walks out of the kitchen door and drives off. That is what I believe happened. Again, this is just my hypothesis. It certainly isn't fact, and we'll take the courtroom for it to be established.
Right, that roommate's going to be a pivotal witness.
Oh, man.
As you would think. But then he goes back the next day, right? Doesn't he drive by?
Well, what they found is his cell phone is in the area. Now, what's going to happen in court is that cell phone triangulations are pretty good just for about 10 to 12 miles. And that puts you in the neighborhood of that house. In Moscow, you can be in a lot of places within 10 to 12 miles. You know, when Amazon delivers a package to you, if they give it to you within 10 to 12 miles of you, that's not considered delivery. And so you really can't substantiate that for Kohberger's presence at the murder scene again. There's a lot of things that the prosecution is saying that are truths that might well be true, but are going to be very hard to establish in a court of law.
They're saying that this trial could last 3 months. The longest trial Idaho's seen death penalty was Chad Daybell last spring, which lasted about 2 months. And as you mentioned, he's eligible for the death penalty. What do you find as far as the community, when you were researching this book, the community and how this has impacted the small community and the university community, the University of Idaho?
That's a good question.
Let's take the university first. University is tried to make the whole killings, the sense of the killings, really go away. They tore down the murder house. This was on the orders of the president of the university. The house, 1122 King Road, is no longer standing.
Yeah, I remember that.
It's just been knocked down by bulldozers because they did not want students who were applying to the university to come with their parents for interviews, and then they'd see what part of their tour would be the murder house. They wanted to make believe that this would just all go away if they tore down the walls. I don't think this is ever going to go
what?
away. This is going to be part of the University of Idaho forever. It's also going to be part of the community of Moscow forever. This is part of Moscow's history. And I think it's, you know, Moscow in many ways is a frontier town. And it's also a university town. And that's the big contradiction in the city or the town. It has the largest church group there is the Christ Church Quaker group, and they're a very fundamentalist church group that's been involved during the COVID era in many protests against the city. But they're also in a town with a very liberal university. This is a University of Idaho is rated by state surveys as the #1 party school in the state. So there's really this tension. A lawyer I interviewed.
The #1 party school in the state?
While doing research for When the Night Comes Falling, talked about the town being at the verge of a civil war. And this is sort of going to exacerbate the tensions in this town.
Mm. So now that it's going to trial later this year, do you plan to do a follow-up book with everything that comes out?
Well, I'm going to attend the trial. I'm going to write about it. Whether or not I do a book, I have to see how events happen. And, you know, we say with great certainty the trial is going to take place this summer. I'm not so sure. I wouldn't be surprised if it gets delayed a bit longer. I think the defense is going to keep on filing motion after motion after motion, doing whatever it can to keep their client out of a courtroom where a trial is taking place.
Right. Well, you know, should he be found guilty and be sentenced to death in Idaho, that doesn't mean he's going to die right away. I mean, it'll be decades most likely before he is put to death, especially with the appellate process and questions surrounding the death penalty. You know, there's so many other high-profile crimes out there, Howard. You've got Mangione in New York. You've got all these other ones. What is it about this particular case, the Bryan Kohberger case, that you think has so many people interested in it?
How much the case blew up on TikTok. Honestly, I think it was one of 2 years ago, 2.5 years ago. 2 years ago, it just went.
I think there are several elements. First, it was the victims. I mean, they were young, they were beautiful, they had their whole lives ahead of them. Xander Kernul, one of the young victims, at her high school graduation, on her high school mortarboard hat at the graduation day, she had written, "For the lives I'm going to change." And now the fact that she'll never get to change these lives, that she'll never get to become what she was meant to be, that her life was just snuffed out, that all these 4 young people's lives were snuffed out. That's so poignant. It's very effective.
Oh,
The other element, there's so many people like myself who sent your kids off to school and you wonder if you're going to be safe. And then you think, could this happen to them? And then there the mystery element, which we've talked about before.
yeah. Like, why did it happen?
Why would anyone do anything like this? I don't think we'll ever get a really rational answer, but still that mystery lingers. There's no murder weapon that's been found. You know, this is a true crime drama that has all the elements of a great detective story and a great affecting personal drama. And that's really why I decided to write a book about it. I tried to bring all those elements together into When the Night Comes Falling.
Yeah, the name of the book, as you mentioned, When the Night Comes Falling, a requiem for the Idaho student murders. Howard Blum, thank you very much. Is there anything you want to add?
Well, just one thing, you know, the subtitle of the book is A Requiem for the Idaho Student Murders. I think that's very important. A requiem is sort of a loving memorial prayer, and I want these young victims' lives to be remembered, and I try to outline their lives with respect in this book, and I think that's also a part of the story. It's not just a detective story, but it's sort of a requiem for these lives that were lost.
Yeah, so many lives affected. Thank you, Howard.
Thank you. Pleasure talking.
And again, my thanks to Howard Blum. His book is titled When the Night Comes Falling. So that.
Oh man, y'all, what's gonna happen at this trial? What is gonna happen? Do you leave a comment right now? Do you think he's gonna be found guilty? Do you think he's guilty? Yes or no? Put it in the chat right now. Do you think he's guilty? Yes or no? And if you think that he's guilty, do you think he's going to get the penalty? Put a thumbs up in the chat if you think he's going to get that penalty. Damn. Crazy as hell. YouTube, do me a huge favor. Everybody watching on YouTube, there's about 100 of you. Hit the thumbs up button for me. Hit the little thumbs up button for me, please, and thank you. TikTok, hit the follow button if you're new here. My name's Patrick. If you like true crime, we're live every single night, virtually. I might take a day or two off occasionally, but we're here every night. So hit the follow button if you're new. Come on in. And I'm out of here. I'm going to bed. YouTube, you're going to go watch some ghost hunting stuff. Go check it out.